Hello. Good afternoon, everybody. I thought, are we waiting for anyone else? Anyone still in the lunchroom? I am Gideon Kamya-Lukoda, an associate director at HKA. I am a delay analyst or delay expert, and I will be moderating the session today on the use of expert witnesses and expert evidence. You've had in the earlier session, in the morning, people were talking about risks, JV partnerships. What we're going to explore in this session is those risks have materialized, the quality has been affected, you've lost time, it has cost you money, and you've probably lost you've lost some profits as a result of that. Then what do you need? Probably you're likely to need expert evidence and expert witnesses. Now, I am joined by distinguished individuals who I'm going to introduce. When I call out your name, you give a short introduction of yourself. Please, I'll begin with Muyiwa.
Good afternoon. My name is Muyiwa Ogungbenro. I'm a partner with Olajide. Olajide is a member of DLA Piper Africa, and I'm a partner in charge of export reservation.
Thank you. Thank you. Timothy? Timothy, I think you're on mute. Timothy, I think you're on mute. Timothy, we cannot hear you. So I think I'll go with Tumi-san.
Thank you, Gideon. Am I audible? Gideon?
Yes, you are.
Okay. Thanks, Gideon, and introduction to our audience. So my name is Tumi-san Mungai. I'm a partner at DLA Piper, and I practice out of our Johannesburg office. My practice focuses primarily on construction disputes, and I've advised various clients on various platforms in relating to projects in Southern, East, and West Africa. So I've got an interest in the topic that we're about to discuss, because naturally in the resolution of construction disputes, we do engage with experts. So I look forward to engaging on this topic with my panel members, and of course from hearing different perspectives from the audience. Thank you.
Yeah, thank you to Mr. Colin.
Thanks, Gideon. I'm Colin Johnson. I'm a partner in the London office of HKA. I'm a damages expert for construction, commercial, and investment treaty cases. And I've been involved with Africa going back quite a few years now, and in total worked in just over half of all African countries in some form or another. And happy to be here, just sad that I can't be there in person.
Thank you, Colin. Thank you, Colin. Timothy?
Hi, Gideon. Gideon, can you just try to mute the speaker on your laptop? I think that's what might be causing the echo on your personal laptop there. Yeah, is that sound coming through okay now?
Yes.
Okay. Yeah, hi everyone. I'm Tim Harwin. I'm also a partner with HKA. I work out of our Johannesburg office. And so, yeah, I'm a delay expert. I've got more than 20 years of construction experience. And over the last 5 years or so, I've been providing expert evidence on delay and disruption on construction and infrastructure disputes. I'm currently appointed on arbitrations, a few arbitrations on the African continent, in Ghana, in South Africa, and previously worked on some disputes in Botswana as well. So Yeah.
Thank you, Timothy. As I get into the nitty-gritty of everything else, I am hoping that by the end of the session, you're going to have a better understanding on how to use experts, what expert witness is, and how it differentiates from just being an expert, and also explore capacity building. Earlier on, people talked about competencies as key issues, but about competency in a dispute life cycle. That's the element. So I will possibly begin with going via the definitions in a sense. Let me see, Tumi-san, I think this question is going to be posed to you. Are you able to define for us what expert evidence is?
Certainly, Gideon, thank you. So the expression expert evidence refers to evidence that is given by a witness whose opinions and the reasons upon which such opinions are based are admissible simply because of this person's knowledge and experience in a subject matter, which enables a tribunal to ultimately form opinions and make conclusions on a matter where a tribunal would not, in the ordinary course, have been able to form such an opinion unless it is assisted by someone who's an expertise in a particular subject matter. I think it's important to note, however, that not all opinion evidence constitutes expert evidence. So opinion evidence becomes expert evidence when one is drawing an inference or an impression or a conclusion or belief in support of or in opposition of something that is to be proven before a tribunal. Generally, a factual witness would only be permitted to testify on things that they've seen, observed, or otherwise perceived in relation to a particular set of facts. However, if testimony involves formulating an opinion, which requires a certain level of knowledge, skill, experience, and training, then a lay witness would not be competent to express such an opinion, and that requires an expert.
Thank you, Tumi-san. Muyiwa. I understand Tumi-san has completed his by talking about an expert being needed. Are you able to differentiate for us the difference between an expert and expert witness?
Yes. So an expert is somebody who has devoted a considerable time to study a certain area, has put himself out there to be somebody who has a considerable knowledge in a subject matter. So that's an expert. But that doesn't necessarily make that person an expert witness. So an expert witness has to go beyond that. He has to show that, first of all, he's an expert, and at the same time, he has given himself to study of being able to give evidence before a tribunal or before somebody who has to make a decision. So it's not just about being an expert. There are other skills that are required or other knowledge that an expert witness need to know and be able to demonstrate to be an expert witness.
Thank you, Muyiwa. Back to Tumi-san. When do you envisage that you need expert evidence?
Thanks, Gideon. I think it's accepted that there are certain subject matters where a tribunal may be either incapable of forming its own opinion unassisted, or where it has certain shortcomings, but where the help of an expert would be very useful. So the key question to be answered when deciding whether or not expert evidence is required depends on whether a tribunal will receive what has been termed appreciable help from an expert evidence on a particular issue. So the test really is a relative one, and it depends on one hand, a particular subject, the relevant witness, and the relevance of this particular and the expertise of this particular witness with regard to the subject matter. So occasions where such appreciable help would be needed is where an expert rather, by virtue of their special knowledge and skill, are better qualified than a tribunal on a particular subject matter. So once we form the view that there is an area in dispute firstly, and that this requires expert evidence, or i.e. requires someone to express an opinion, that is where we would get an expert on board and brief them to assist us.
Thank you to Ms. Sang. I note you mentioned that the test of deciding whether you need an expert evidence is a relative one. Just as a follow-on question on that, what kind of expertise do you normally require in resolving construction disputes? Oh, Ms. Sang has lost the connection. Muyiwa, are you able to?
Thank you very much. Depending on the issue in dispute, there are so many areas where you might require expert evidence. Specifically, when you are talking about construction disputes, it could range from an expert in civil work, or in electrical work, or even in quantifying the damages that have been suffered by one of the, even in project management. It could be in any area of the project that you may then require an expert. And it could also be that you need an expert to quantify things like financial losses and things like that. So those are the kind of experts with evidence that you might require.
Thank you, Muyiwa. As we wait for Ms. Sang to come back, then building on that, depending on the experts, how do you go about choosing the right expert?
Yeah, choosing the right expert is, first of all, I think you first of all need to determine whether you need an expert on a particular subject to give evidence. So, I mean, a lot of the time you have to assess whether what you need to prove before a tribunal, and then determine whether that evidence will be better coming from a factual witness or from somebody who has given this who has a considerable knowledge in the subject matter, and then has also given attention to the question that you are going to pose to that witness. So you have to then determine whether you need an expert witness before you then even determine the skills that is required. Then, sorry, somebody. Then you then need to determine the capacity of the expert. For example, in a jurisdiction like Nigeria, you need to determine whether the expert that you need is able to testify to the issues in dispute. From my experience, what we found is that it's sometimes difficult to find an expert who is able to give evidence on big ticket cases within our jurisdiction. So you have to look into all of those issues to then determine what kind of expert am I going to appoint for that issue. And then you also need to look at the experience of the expert. It's not just somebody who says I'm an expert, but be able to say that you can give evidence before a tribunal, and you also need to be able to assure yourself that this person able to withstand this time to your bit or to withstand question that will withstand because that person to think on his feet, who has very good effective communication skill, able to convince somebody else about what he has put in his report. So those are the kind of skills that we look at for when we are appointing.
Thank you, Muyiwa. Tomi-san, is there anything you can add on how you'd go about choosing the expert for your matter?
Yes, certainly. So there are a number of traits that lawyers generally look out for when appointing expert witnesses to make sure that not only do you have the relevant expert for the subject matter, but you also have one that's likely to be accepted by the tribunal. So some traits go without saying, really: the expertise in the relevant field, credibility, confidence, and of course, a friendly demeanor towards a tribunal. However, for me, it boils down to two main traits. Firstly, experience. So whilst the relevant professional experience is always a requirement, additional experience over and above that in the form of public speaking, teaching, and of course, prior experience before tribunals will indicate whether a potential expert is likely to be a strong witness in the box. So in our experience, professional experience alone is never sufficient to make one a great expert. The reason for that is with such additional experience comes effective communication to the audience, i.e. the tribunal, being able to think on one's feet, and of course that dynamism that is required of an expert to improvise where necessary and appropriate. And lastly, generally to keep up with proceedings as they unfold. The second trait is the ability to educate your audience so that best experts can convey what is otherwise a complex issue to a tribunal in a very simple and straightforward way. So we look for experts who will be able to, who will be able to convince and persuade a tribunal, and whose opinion will carry the day and will be acceptable to the tribunal.
Thank you. I note with interest you mentioned that the expert evidence is needed to assist the tribunal. So in that regard, where tribunals draw the line between the facts that they can make their own conclusions and those on which they need expert evidence on?
Thanks, Gideon. So a number of general principles are used in various jurisdictions to aid in determining, firstly, whether expert evidence is necessary and whether or not it'll be relevant to a set of circumstances. And these can be summed up as follows. So firstly, the expert witness must be called to give evidence on matters calling for specialized skill or knowledge. So earlier on, I said it shouldn't be a factual issue, but it must be something that requires specialized skill and knowledge of a particular expert. Expert testimony will only be introduced and accepted by a tribunal if it is relevant and reliable. So it must be introduced with a possibility of assisting a tribunal on a scientific or technical issue that a tribunal cannot determine by itself. If at any point it's proven that a tribunal can make its own conclusions on the facts, then I'm afraid expert evidence will not be relevant and will be unnecessary to lead it under those circumstances. So ultimately, expert evidence will only be admissible and necessary if it is able to put the tribunal in a better position through the opinion of an expert. Thank you.
Thank you to Ms. Sang for that. And I think probably for the audience may be full of lawyers here and probably clients, and they will be interested in this. In relation to experts, what do you often look for? What do you look for in an expert? What do you to Ms. Sang?
Sorry, I lost you there.
What lawyers generally look for in an expert? Yes. What would you as a lawyer generally look for in choosing an expert?
So as I said, would look to the experience and expertise, overall demeanor, the relevance of a particular expert's expertise in relation to the issues in dispute. And of course, there's a few sort of do's and don'ts that we also sort of referred to in relation to that expert's work. So we want someone who will be able to keep their message simple and succinct, and who can pitch an opinion to a tribunal in a manner that is acceptable. Of course, we don't want an arbiter of fact when we engage an expert. So someone who would, yes, rely on the facts to the extent necessary, but be able to draw on their own expertise and knowledge in ultimately assisting in resolving the issue in dispute. So that is what we'd be on the lookout for as lawyers, Gideon.
All right, thank you, Tommy Sang. Just for the benefit of the audience, I know Muyiwa did clarify at the beginning the difference between expert and expert witness, but I'm going to be using the terms interchangeably. So bear with me that when I'm referring to expert, I mean expert witness and not just expert. And Muyiwa, are you able to comment on what Tommy Sang has just said? Expert witnesses needed in each and every formal dispute forum. Expert witnesses needed in each and every formal dispute resolution forum.
Yes, I would say yes. More can have that in itself speak that you need an expert who will do the determination itself. And then even in making your presentation to the expert, for the expert determination, you need an expert that will guide you do your own assessment you may want, and then your own assessment as you may want, and then you move there, from there to adjudication, and then still the same issue. You need an expert to get you through this, and then you have either your arbitrary process, have the arbitration, or you have your court. You also need an expert witness for those kind of proceedings to be able to establish your claim or your defense before the court or the.
Thank you. Thank you. Of course, you can make your revision to hear me. You've had the lawyers they look for in expert witnesses. Is it always clear to you what the lawyers are looking for in you?
Sorry, Gideon, I think, was that to me? We lost the feed slightly.
Yes.
Okay.
Is it always clear to you what the lawyers are looking for when they appoint you?
It's often clear what the lawyers are asking for. It's not always as clear necessarily what the case requires. And so I think not just from our point of view as a damages expert, that's perhaps clearer, but when you come into some of the technical aspects, in particular on construction disputes, I've heard some of my colleagues explain that although the client may think that the problem is in a particular part of the plant, actually once they start to investigate it's somewhere else entirely, which may need different expertise. So I think it's the challenge in terms of that selection of the expert from our point of view sometimes is that you actually need some dialogue with the expert to determine exactly what the question should be. And so, it's where we have that explanation of some of the preliminary facts, discussion of what that may give rise to in terms of issues, and then based on that in terms of issues, it can help to determine what is the best skill set, if you like, in terms of an expert. And just to be clear, you were talked through the expert and the expert witness. When you're actually picking your expert witness for a case, you have a choice very often between one extreme, people who have never been an expert witness before, but may be extremely expert in their field. Engineers who've been working on a similar sort of plant for the last 30 years or more, but never had to do so in a conflicting and a contentious situation before a tribunal or before a court. And on the other hand, you have the professional expert witness who is actually, their livelihood depends on them giving the expert witness evidence time after time to different tribunals. This is what Doug Jones, for example, refers to, where he says he prefers that because he knows that their reputation for independence is important to them and can be valued in that basis. But it's just a question of, there's not a right answer for every case. It's one of actually looking at, is this so niche, is it so specialist that actually you really do need the person that can explain the issues and explain those clearly. I think it was Tumi-san that talked about explaining the issues clearly to the tribunal. Is that best done by somebody who's an expert, even if they're not an expert witness normally? Or actually, if you're going through the sort of thing that Tim does in terms of delay, for example, is it far better to have somebody who's very used to the discussions that will go backwards and forwards between counsel and experts on the tribunal on the different ways of assessing delay and actually being able to feed into those? So that's really from the expert's point of view, when we get the initial message from the lawyer, why you will sometimes see us not just say thank you very much, right, okay, we'll start to write a report, but we'll actually start to ask questions. It's trying to actually just make sure that we're working together in terms of delivering what we need to for the tribunal to best help them in terms of their decision.
Thank you, Colin. Tumi-san, I can see you're back. Are there any 2 or 3 issues that you'd advise an expert witness to do or not to do?
Thanks. I think I've alluded to at least one of them. And I say, there's a famous quote by Einstein: if you can't explain it to a 6-year-old, you probably don't understand it yourself. And I don't for a second suggest that 6-year-olds should understand delay and disruption, but perhaps in this context, we can rephrase it and say, if you can't explain it to your legal team, you probably can't explain it to the tribunal, who more often than not would be lawyers. So we prefer experts who are mindful of their audience. And the audience, as I said, will more often than not be technical people. So we encourage testimony that is clear and precise. And the other one I'd already alluded to, but I'll repeat, more often than not, we come across experts who fall into the trap of being arbiters of fact. We say, leave it to us and our clients and focus on your expertise, which will be greatly appreciated. Thank you.
Thank you to Misang for that. I am sure that the perspectives you've had so far resonate with a number of you, and that you have a clear understanding what expert evidence is, what an expert witness is, and that you start reflecting on whether you may need them on whatever matters that you may be working on. If I move to the experts, Colin, from your perspective,
I'm sorry, Gideon, you're going to have to repeat that. I wasn't coming through clearly.
I broke up.
Yeah, afraid so.
From your perspective, how do you think the parties should choose the right expert to act as an expert witness?
It really is that sort of getting a joint understanding of what the true issues are in terms of the case. And then it's, assessing who your tribunal are, assessing the cost, because obviously not all experts cost the same amount. How much is at stake? How much is it worth spending on this? So it's really just that evaluation of picking up really what are the key issues at play here.
Thank you for that. Just to that, thank you for that. Just to add to that,
I'm sorry, Gideon, that wasn't coming through again.
It didn't come through properly. Will the same expert be suitable every time?
No, definitely not. Definitely not, because it's only, whilst one expert may cover a range of issues, and again, I'll pick on Tim's area in terms of delay. A delay expert is able to deal with delay across a broad range of different projects. There may be times, for example, when we are looking in terms of damages, if you're looking at somebody that assesses profit and loss of valuation, that's not necessarily the same person who will assess costs incurred on the ground in terms of construction site additional costs. And similarly, if you're looking at some of the technical expertise in particular, just because somebody has worked on a power plant before doesn't mean that they will understand the specific issue that is in this case. If this time is boilers and last time was connection to the grid, it's not the same thing at all from a technical point of view. So it's certainly something that has to be weighed up carefully in terms of what the actual issues are.
Thank you, Colin. Timothy, this one goes to you. Colin has just said that the same expert will not be suitable each and every time. What do you think are the key characteristics that should be taken into account when choosing an expert witness?
Yeah, of course, that experts, all the reasons that Tumi sang and Muyiwa just set out quite well earlier, the characteristics and the personality of the expert, having some confidence that they will be able to pitch their opinion, I think was the phrase that Tumi Sang used, and that's quite a skill to being sort of selling your opinion and trying to advocate for the case, and there's quite a distinction between those two things. So being able to have that confidence, I think in that expert, in their expert witness skills, but also in their expertise. And as Colin just said, making sure that their background or their expertise fits to what the matter is to hand. And I think that the thing that can't be overlooked as well, especially on large disputes, is the value that the assistants and the lead assistants bring to the expert report. And so making sure that horsepower is there to get across all the facts, do the required analysis, and those assistants also need to have some sort of understanding. So I think getting your hands on the experts, the CVs of the experts' assistants is sometimes almost as valuable as the expert, the CV of and the experience of the lead expert. So I think it's a mix of all those considerations when choosing, and their availability as well. I think we've all been there in our professional lives where you overcommit yourself to things, and so making sure that expert, the current commitments, not going to hold them back from getting across all the facts and doing all the necessary, producing all the necessary reports and engaging with the issues at hand, which can drag on for a year or two. So just ensuring they got the capacity to put their skills to good use.
Thank you, Timothy, on that. Tumi-san, anything to add on the considerations of choosing the right expert to act as an expert witness?
Perhaps from a timing perspective, I can add a few things from a lawyer's perspective. So ordinarily, we'd want to engage with the experts as soon as a matter commences, and once we formed a view that we require expert evidence. Sometimes it is obvious at commencement of the matter that there'll be an area that requires expert evidence, and of course we engage an expert early, and we've seen the benefit of such early engagement in the number of matters. It enables us to walk the path with the expert, as it were, while obviously maintaining the lines of independence in the ordinary course. Sometimes it's not as straightforward and clear as one would like to have it at commencement of the matter. And we do appreciate that we have a duty to give the experts instructions that are very clear and would enable them to fulfill their instructions. So
I think we've just Tumi-san's just dropped out.
Yes, I think we've lost Tumi-san. Muyiwa, anything to add before my next section on that? Tumi-san.
I think Tumi-san was getting into when should we introduce experts into what we do, and was talking about the early engagement of experts, and I think that's what everybody will agree with, that the earlier you engage the expert, the better for your case. You don't wait until when it's just a week into or something like that, when you need to turn up your expert report, and then you are just engaging your expert at that time. So early engagement is usually what is preferable.
Thank you, Muyiwa, on that. Colin, you have extensive experience working across Africa and elsewhere indeed. I'm sure you've come across numerous war stories, both in experience or you've heard about. Are you able to draw on that and bring to life the pros and cons of using an expert?
Sure. So let me pick on a few, if you like, and just describe. If I pick on one that was in relation to a gas concession, and it was only by sitting together with myself as the expert and with the legal team, and this was because there was early engagement, that we started to discuss the case and realized that actually there was a big hole in terms of the case in relation to the marketplace that the gas was going to be exported to, because it was a landlocked country where you would not be actually able to use that gas in the local market. There wasn't a local gas market, and it would literally have to go sort of over the mountains and get connected elsewhere at considerable time, cost, and risk in order to actually find a marketplace. None of that had been factored into the claimant's arguments. And so by sitting and going through that, it made a very big difference to the way that the case was defended from the outset. So that's one clear example for a start. Another one is talking about termination in terms of construction contracts, and actually for termination in relation to housing when a large amount was being claimed, you're able, from a damages point of view, we were able to actually pull out some of the prior financial accounts for the same construction company and demonstrate that the sort of amounts that they were claiming they'd never achieved in any of their prior years on any of their prior projects, so that you're not able to assume that this was suddenly going to be your best project ever. There was no reason that would apply at all. So I think that's the sort of thing that we start to pull out. And maybe just one final one, the claim for delay in construction in relation to a power plant, and some of the major costs caused by delay because it was a replacement are actually in relation to fuel supplies. The challenge there was in relation to actually who paid for the fuel, because there was a pass-through mechanism to an off-taker. Off-takers were related parties, so could actually bring the claim in their name, potentially, as well as in the direct company name. There's obviously legal issues at play here as well, but this is where this interplay between the legal and the expert roles is so crucial. And the point is that by sitting and talking with the expert and realizing where the real losses are and what's going to sort of make the big difference to the numbers, is how the lawyers are then able to better shape the claim in terms of achieving what their ultimate clients want. Hopefully that helps, Gideon.
Yeah, thanks, Colin, for that. Bringing out the war stories which communicate the value of an expert on legal matters. But now, are there any downsides to using an expert then?
The downsides are, time and cost, essentially, and possibly maybe a third one of distraction, in the sense of if it's not a key area that's going to make the big difference to your case, do you really need that expert witness on it? But in most of the ones that we look at, obviously, the value that's brought by the expert outweighs the cost and the time significantly because of the sort of issues that I've just described. Because it is, even with very experienced lawyers, we're looking at things from a different point of view, and so it's that sort of interplay between the lawyer team, the legal team, and the expert team that can actually create new thinking in relation to the case.
Thanks, Colin, on that. Timothy, you've had Colin articulate to us the value of using an expert. When do you think is the best time to appoint an expert?
Well, as early as possible, I would say, generally speaking, and Colin, the benefits that have just been outlined with some examples by Colin of how some of the expert experience and expertise that they bring can help lawyers focus the dispute. So that's an obvious benefit. There are a few other practical benefits as well that I've seen of getting involved in a dispute or being instructed on a dispute earlier, and that's just access to information. Generally, an expert witness is bringing a backlog of experience around on similar matters, whether it be an infrastructure or an energy dispute or a road or a commercial building, and if they've got some relevant experience, they can quite quickly get to what are some of the core documents and core information that's going to be fundamental to carrying the day in the dispute. And as the project gets more in the rearview mirror, perhaps finishes, or the dispute's only just starting after the project's finished and the expert hasn't been engaged yet, getting to that information just can take so much longer. And in a finite time period of an arbitration proceedings, it just makes the available information and the use of time to produce expert opinion and also other legal submissions. It's just can drag on and make all that quite tough. So I've got a couple of recent experiences. One on a commercial project in South Africa, and I was engaged while the project was still ongoing but nearing completion. And that just afforded me the opportunity to meet with the project team and the lawyers quite early on and put my finger on the types of information that are going to be essential. And there was quite good records there with photographs and daily reports and things like that. And so I was able to get a nice collated version of all that information, which gave me more time to do my analysis. And I think my report and opinion stood up quite strongly as a result. And I've had, in parallel, had another matter, which was a mining infrastructure project. And although the records, it turned out after many months, were there, it just took so long to get to them. And then I lost the benefit of perhaps consulting with the project team, with the lawyers, and understanding what that information meant. If I saw something on a photograph, is that what am I looking at what I'm thinking I'm looking at, and does that support that opinion or that assessment? And that benefit of time was lost. So I think, just to support everything that Colin said around early engagement of experts, if possible, is preferable, just for those practical reasons alone. But there are probably a number of pitfalls that you just need to be mindful of. One is letting an expert loose, for want of a better term, without some sort of direction or some preliminary instructions on what to look at, that perhaps just can have a cost create a cost problem just with the fees that the expert and its team might be racking up on potentially unuseful assessments and looking at information that might be unhelpful. So just trying to get that alignment with that dialogue that Colin spoke about. So that's probably the best way to avoid that. And then there's, if the expert's engaged too early when the dispute hasn't crystallised, there may be a perception that expert is somehow tainted or dirty because they've helped to produce some sort of project claim, or and they're somehow partisan in this. So just be mindful of keeping that legal barrier between the experts and the project team, just to ensure that the expert isn't advocating at the project level and then trying to come in the dispute and present themselves as independent and impartial. So just be mindful of that when early engaging an expert.
Thank you, Timothy. I picked out that one, you need to engage the expert early on, and the challenges Colin mentioned. Think about the costs. Colin, to build on that, early engagement costs. How best can a lawyer use an expert throughout the different stages of the dispute life cycle?
Sure. So that early chat that we're talking about, as Tim said, doesn't mean that you say, right, set a full team on this from day one and away you go for the next however many months, or in some cases years it is. It is about picking what level of involvement you need from the expert at each stage. In that first stage, you really need just the expert, or the expert plus one senior person maybe, to actually talk through the issues and to sort of explain how they, as an independent expert, see the issues. And then it's up to the legal team to then formulate the strategy based on what they know about that. and I phrase it that way because it is important, as Tim said, to make sure that that dialogue is in the right way, because an independent expert can't be advising on strategy and can't be putting together the numbers that they then actually revise afterwards. So those two are important. Then as you actually go through, once you've got your instructions agreed, it's just making sure that you've actually got the information shared with the client, or from the client, should I say, in particular. So at times that may mean somebody actually sitting with the client, whether it's the expert or whether it's somebody from the legal team, or pushing to ensure that the right focus is given, particularly on a live project, because people are busy sort of still doing other things on the project. But equally, what does happen if it's a project that's already finished is you've then got the team that's gone elsewhere. So either way, get the client to understand the importance of the right data. If the expert doesn't have the right data, their job is a lot less effective. So really sort of focus then on the data. In terms of working with the experts on the reports, just make sure that you tread that fine line between ensuring that the report is being presented in a way that will be understandable to the tribunal, and that the sort of that is coming across clearly without making it a legal document. This is the expert's report for lawyers to comment on. It's not another legal submission. And most experienced arbitrators will know the difference very clearly when they read a report. And it doesn't help your case if you make it a legal submission in most scenarios, I would say. So make sure you do that. And then the final thing, when you're coming through towards the hearing phase, the final section, if you like, first of all, make sure that you keep the expert aware of changes that have come out, extra documents that have come out, some extra witness statements that have been made, all of the things that could actually impact on their opinion or could take them by surprise when they're being asked questions. Use your experts when you're actually preparing your own cross-examination of the other side, or use their senior team to make sure that the cross-examination questions make sense and are actually the relevant ones. And then finally, also just get the experts to read transcripts and to feed into post-hearing briefs, because again, there can be some misunderstandings along the way, or some extra things that they've heard and they know exactly what was being said because it's the vocabulary that they use day after day. So just make sure that you use them there as well.
Thank you, Colin. Muyiwa, you've heard what the experts have said. They've said they want to be involved early and probably set out how they want to be involved across the dispute life cycle all the way to the hearings, indeed. Have you got any further thoughts to add to that?
Yes, yeah, definitely. The best practice is to engage the expert as early as possible. But sitting as a lawyer who does this thing, sometimes, or most of the, let me say most of the time, sometimes it doesn't come that easy to come to that conclusion that, oh, we will need an expert evidence or expert witness that will have to testify for us. And it also depends on the kind of pleadings that you are looking at. If you are using the memorial pleadings and all of those things, yes, you might need the experts. I mean, you need to engage the expert early on and all that. If you are using the other one, which is common in the, I think in the common law jurisdictions, you've got to see the pleadings sometimes. You've got to see what the other party is saying, where the issues are, what is really the dispute between the parties. Sometimes, which is why we delay in engaging the expert. I hear you. Early engagement is still the best, but sometimes you just don't get to that point where you are able to determine right from the beginning that we're going to need an expert to be on this project with us.
Thank you, Muyiwa, on that. I hope that as per what we've had so far, we all are clear on the value experts can bring to your matter, and that expert evidence can be helpful in in whatever matter you're progressing. The next set of questions actually go to something I'm very passionate about. And I'm cognizant that people have just had a little bit of lunch, so the sugar levels are increasing, the heads may be dropping. So could I ask everybody to stand up? Everybody stand up, please. Those online as well, it's good for your health and safety if you stand up. Spread your hands out and say you believe in experts. Believe in experts. Eh? So get the energy flowing, believe in experts. All right. So I hope that allows you to to get the sugar to calm down and become alert. Thank you. Sit down. No, we can't sit down. We can sit down. Is Tumisang back? All right.
He's back, but not visible, we believe.
He's back and not visible. Not visible. So the next topic, really, why I say I'm very passionate about it, goes to capacity building. The challenge why we don't have many experts turning into expert witnesses in Africa, where continually on the continent, people are still importing expertise from elsewhere to come into the continent. So I will probably, if Muyiwa is not yet back, Tomisang is not yet back. Question is going to Muyiwa. How do lawyers determine if an expert has the required experience to act as an expert witness?
That's a little bit difficult. There are so many factors that come into play where I practice. It could be an area where you have so many experts who can testify for you. Then it comes down to cost, and it comes down to what your client also prefers. Because all of these factors, you have to look at them together to determine whether you are going to engage a particular expert. And then I've talked about cost, and then the whether your client will agree with you, and the issue of also whether how critical is the evidence to your case. You also have to weigh that against other factors. If is something that sometimes you have to look at who has the burden of proof, which we have done a number of times. You might look at it and say, on this particular issue, I don't. The burden of proof is on the other side, so I will wait for the other side to probably call in an expert evidence to prove that point before I then determine whether I want to engage an expert on that point. And so there's so many factors that we consider before we appoint experts.
Thank you for that. Now, from what you've said, so many factors. In your opinion, is there such a thing as a bad expert?
Well, you might not start out as a bad expert, but we've had experiences where you actually have somebody who then turned out to be a bad expert. Either because, not necessarily because of the report has not been prepared well, but because they were not answering the question well. During cross-examination questions, they are unable to properly defend the report that has been prepared, or to even look at the other party's report critically and give an honest and independent view. And so you have, sometimes the experts get caught up in the case sometimes, and then they are unable to maintain the independence that the tribunal is looking for. So all those things can make an expert a bad expert witness.
I know you've touched on a few things, experts not being able to maintain the independence. Are you able to elaborate further on the challenges you've experienced working with experts?
Well, I think I'll start right from the beginning of even identifying an expert, especially in a country like Nigeria. There are so many experts in different areas, but the issue is, how do you identify somebody who is an expert witness? What do you consult to find the expert witness that you are looking for? And you discover that the information is just not there. We have experts, but we don't have many expert witnesses. So, which I would say that the feasibility for many of those who are even expert witnesses, the feasibility is really poor. And that's part of the problem that I have with expert witnesses.
Thank you. To build on that, Timothy, you are an expert. I know you're based in South Africa, and Muyiwa just mentioned about visibility. What do you think are the obstacles faced with increasing experts as becoming consultants in Africa?
Yeah, well, the obstacle and the challenge is getting that exposure and getting that experience and getting your first appointment. So that's the challenge. And it's very difficult to go straight from being an industry expert or a specialist in a particular area, whether it be an accountant or an engineer, and then going straight to giving evidence at an arbitration. And you have to take the steps along the way, which is to work and get some dispute experience. And that's probably going to be as an assistant or a lead assistant. So that willingness to understand and take some time to get some exposure to disputes, and so that's that's all relevant to any budding expert anywhere, not just people experts and specialists in Africa who want to get into the world of expert witnesses. So yeah, and that expert probably needs to learn how disputes are run and the various deliverables. It's not one report, but then there's a reply report, and then a joint process, which is it's a whole animal of its own of how to produce a joint document with an opposing expert. How the words that you use and write, how they're going to be tested and scrutinized by opposing legal team and counsel, and the importance of articulating the rationale for your calculations, which result in your opinions. That underlying rationale is almost as important as the calculations themselves. So understanding all those things, it just takes time and you need exposure. So to do that, sitting underneath the lead expert, whether that lead expert is from Africa or not, that's how we can build some capacity. And I think the way that we can encourage that, and that's probably for experts and for lawyers to think about, is to, if you're appointing an expert, just as something I touched on before, is understanding how who they're going to have working alongside them on the dispute. So their assistant team. And so when appointing an expert, ask for their CVs. If there is a opportunity for them to use someone based in the same region within Africa or potentially in the same country. So a local-based expert assistant can be invaluable just in terms of document management. This is a project visit that's required or something that can perhaps that expert can, the assistant can do that type of work. And then as a function of all that, potential experts going to get the experience needed and build a rapport with lawyers, and then ultimately take on their own appointments. So I think there's an obvious challenge there to getting the experience, but I think it's not something that if we all try to use African assistants, then I think we can start to increase that capacity.
Thank you, Timothy. Now, keeping with the theme of the conference, from hindsight to foresight. Muyiwa, how do you suggest we can increase the involvement of African experts in dispute resolution?
I'll say that there should be more engagement between or among the lawyers and the experts, witnesses. In other jurisdictions, there are probably protocols in place where you know what is expected of an expert witness. In Nigeria, I'm not aware of any such protocol. So there has to be a lot more engagement between the lawyers and then the expert witnesses.
Thank you. Colin, from your experience, have you got any thoughts on how the level of African experts can be increased and any challenges you've faced working on the continent?
I think one of the biggest challenges often is visibility. Stating the bleeding obvious, it's a big continent. So people can be in one country, if there's not the networks there to share that knowledge across, it's less visible. than it might be in, say, a bigger center like London or like the US, where it's sort of there's a lot of people concentrated very often in one city. So I think the visibility angle is key in terms of bringing that out, and obviously things like this event, directories can all help. The bigger law firms keeping their own records in terms of what experts they know where across the African continent, all of those can help. And then I think it is an element of shadowing, and that's something where perhaps from a law firm point of view, if one of the requirements that is put in, it may not be an absolute, you must have this, but when you're asking for your expert teams, ask, how they will ensure that they address local issues in the country or the region concerned. That in itself will encourage the expert firms to look for and involve those who've got the experience, who are actually from Africa. So I think hopefully those sort of things would increase what we look at doing going forward. Then I think there's also programs that do cross-examination training, which is done obviously from the benefit of the lawyers very often, but it can also benefit young up-and-coming experts, because they get to both practice their skills and also to start to show their skills to lawyers. So even if they can say, well, I haven't been cross-examined in a live case, but I have been cross-examined in a moot, in a training type session. So those are some of the ways that perhaps can all help.
Thank you, Colin, on that. Timothy, anything to add to what Colin has said?
No, I think, I think that's that directory suggestion that Colin made is potentially something that perhaps this organisation, African Construction Law, could think about. And I think he also picked on something which I didn't mention, which is that formal training. And there are various organisations around the world who provide that, and I've personally been through some of that, and I found it very useful. Just having the simulation around cross-examination has been, so training's also a very good way to develop African experts.
Thank you, Timothy. Now, you mentioned formal training. Now, we know the experts, as Muyiwa explained, are anybody who is competent. And possibly countries like Nigeria, Uganda, South Africa do have professional registers from professionally qualified engineers, quantity surveyors that you could draw on as experts. Then who takes the responsibility to allow these experts to transition into expert witnesses? Could it be the legal profession not missing something? Muyiwa.
First of all, I think, like you said, we've got various experts. Number one thing is we need more people who are willing to take on expert witnessing as a profession. First of all, not just you heard that, there's a dispute somewhere, they need somebody to testify on something, and then you are catching up. So I think that's where we need more people who will put out themselves as expert witnesses. And then you can then start to talk about trainings, seminars, and even the collaborations between expert witnesses and the legal profession. So until we have this body, a sizable number of them, we don't really know who we'll be working with. So we need them to come up, expert witnesses coming up as the association. Then we can then see how we can collaborate with them.
Yeah, thank you. Tumi-san, I see you're back online. Anything you could add to what Muyiwa said?
Yes. The joys of technology. Apologies, everyone. I think as a legal fraternity, we do have a big role to play. More often than not, we are the ones that propose the experts to the clients. So we need to make an effort to know the expert, but equally, we also need a bit of visibility from the expert's perspective. Most of the time, especially where the cost doesn't warrant an international expert. It's not from a lack of trying that some colleagues more often than not would go to the more established international expert entities. So visibility is something that's key, but we could also play a role in that, assist in that word of mouth marketing of some of the expertise that some of the colleagues probably don't know about. So there's identifying the experts. We've got a big role to play in terms of ensuring exposure. So even in the big mandates where we involve some of the big international entities, surely there's a scope in ensuring some sort of a training arrangement to be put in place for that skills development. So another area where we could probably have a role is in formalizing the industry, coming up with professional codes of conduct, which would enable uniformity, globally. So when you're engaging an expert in Johannesburg, in Lagos, and in London, it should be that they subscribe more or less to the same codes. I think I think that'll go a long way to making sure that we continue to see a lot of collaboration across the experts. And lastly, I think a challenge should also go to the African experts to say, firstly, get involved in conferences of this nature. I'd be interested to see how many African experts are actually in attendance and in the audience, and be visible, be vocal, write opinion pieces about your expertise, put yourself out there, let us know you, let us engage on the subject matters, because I think we all have a role to play in developing construction and the construction industry after all. So I think we all have a big role to play in making sure that we can easily source experts out of the African market.
Thank you to Ms. Sang. I think as you've heard, capacity building wise of experts, every person has a role to play. Both visibility wise from the experts and also legal profession, putting the right protocols in place to help them bridge that gap. The professional registers and directories do exist. It's just about getting the interest, as you mentioned, and nudging them into the field, because we all do benefit. On to that, I will probably add one last comment. Nothing happens unless you make it happen. So if we want to get there, the lawyers have a responsibility, the experts have a responsibility to make it happen, right? So that concludes the main session. Now we go into questions and answers from the audience and from line. Now, I did try to log in here, try and see if I can catch up with any questions, but my IT has failed me. But I can take questions from the audience, and if the people at the back know what is online, they could let me know. Yes. You can hear.
Hi, my name is Bankole Shudipo. I'm a partner in Geo Shudipo & Co. and a professor at Babcock University. How useful, and I'm asking this question based on some developments in some recent arbitrations involving Nigeria. How useful do you think is a conference with experts where there are conflicting experts witness, and then the panel just wants to reconcile, have the two of them together in terms to be able to reconcile and help them in taking a decision? That's one. Then the second one is difficulty sometimes with getting experts. Private parties, government entities are often slow in responding to calls for expert. I mean, you find out that you have a timeline, but the ministry is not responding. So the question, what do you suggest counsel should do where he considered, I need expert witness, but the client, whether ministry, government, or private party, is not responding to the call for expert witness? Should he just go and fish for one himself, or what? Thank you.
Thank you. You've bundled quite a lot in one go there. Tumi Sang, have you been listening? Muyiwa,
Yes,
are you able to?
Yep.
Yes. Well, hold on. Yes, Tumi Sang, go first, and then Muyiwa will add on to that. There are 4 questions bundled into one.
Yes. The one that I picked up is how useful is what is normally known as hot tubbing, if I understood correctly, such that at some point the tribunal would would want the parties to sort of come together and agree common cause facts. I think it's useful for the experts to always align. In fact, in an ideal world, you'd want the experts to have the first sort of starting point, access to the same data, etc. In the case of a delay expert, you'd want them to use the same programs, as it were. So for me, that exercise is useful if done correctly. My sense, and I hope the question wasn't sort of suggesting that the tribunal would want one expert to adopt the view or the other, but it certainly helps to narrow down the issues, which would then be left for determination by the tribunal. The second question, if I understood it correctly, or at least the second part of the question is, what do you do if clients are non-responsive to a call to employ experts? It's a bit of a difficult one that I personally have not encountered. I suppose it simply leaves that issue that requires expert evidence sort of either unaddressed or not sufficiently addressed. And I'm not sure from a lawyer's perspective whether there's much you can do if a client does not accede to your request for to bring expertise on board. But I'd leave it at that. Perhaps Muyiwa could shed some more light on that.
No.
Yeah, on the first question, I think that in my own experience, I've not found the expert conference to be anything useful. Most of the time, in my own experience, the experts, they go with I mean, they've already determined that I'm not going to take anything from the other party, especially when what you are taking evidence on is even on a legal point. Lawyers just go there to tick the box and say, we've met, and that's it. They prepare their report and then they move on. Then on the other question about requiring some sort of expert evidence from government and they're not forthcoming. And I think I identify with what Professor Shodipo said. There are certain issues that only government can give you their own observation of what happened. And then you go to them, you apply to them, they are not forthcoming. And I've seen it as well. What we've tried to do is to see how we can circumvent that and see whether we can bring in an expert to then look into the issues and then prepare a report. But oftentimes, you found out that you probably have lost the moment when an expert should have done the examination. So you end up, most of the time, having to wait. Either you have to wait for the government to get around, or sometimes you just have to let it go.
Thank you. No, probably we can address the question that we have online here. Do directors have the answer in relation to how do lawyers determine if an expert has the required experience?
First of all, I'm not sure whether it's really a lawyer's call to determine whether somebody has sufficient experience. But we still, in my own experience, we still, make that decision either with the client or some other people within the client industry saying, okay, this person has sufficient knowledge and experience to testify on this particular point. But really, I don't think it's just lawyers' place to make that decision. Depending on the issue that you are dealing with, if it's legal point, I mean, it's easy for us to say, oh, this person should be the appropriate expert witness. But above all, what is critical is that whoever that is being recommended, the lawyers need to meet with that person as soon as possible before cost is wasted, and because you need to assess whether that person is even able, to give evidence. Something else to prepare the report, to present it before the tribunal and to be cross-examined on it is another thing. So it's all of these things combined together that will determine who you are going to appoint.
Thank you. Yes?
Yes, good afternoon. Oh, sorry, good evening. My name is Osinachi Wandem. I am a senior associate at ALEX. My question goes to the experts, and it's around the experts' witness role in delay analysis. And I know that there are times the expert could deploy or combine different delay analysis methods. And we've been discussing about the fact that an expert report must be comprehensive. So my question is, how will you go about this as an expert, where probably you have to deploy or combine different linear analysis methods and ensure that it's acceptable by the tribunal, meaning that it's comprehensible? And I don't know, that's the question. How do you go about that if you have to combine several delay analysis methods?
Yeah. Thank you for that. Probably I should answer this, but since I'm just a moderator, Timothy, as a delay analyst, over to you. How do you determine the delay analysis?
Gideon, don't let me steal your thunder. If you want to have a answer it, then by all means, let's hear it. No, okay. If I understood the question correctly, how can a delay analyst combine different methods to make sure that the tribunal has a comprehensive set of analyses in front of them, is not something I come across too often. Normally, an expert chooses a method, explains the rationale for choosing that method, usually informed by the contract, tells them what to do. The available information is the second consideration, and then what are the issues in dispute? Probably the third main thing. And based on all of that, there should be a well thought out method to assess delays on a project. Now, there can be more than one or two ways to do that. And as the industry's evolved, the methods are becoming a little bit closer together. So I think, just from a functional point of view, you can do your primary analysis, and then in an appendix to your report, just do a supplementary analysis that if I were to look at it this way, this would be the answer. And you should ultimately arrive at the same answer just by a different route. And you can just explain if there's a difference, it's because you're looking at something prospectively or retrospective. And if you exclude that not known fact from the future, then this would be my answer, or something like that. So I think it's just a structural presentation way to combine analyses. It's not a matter of actually putting two analyses into the same software or something. I don't think it needs to be merged. It just probably needs to be aligned side by side, whether it's opposing expert reports or two analyses that I've done with different methods, but just putting some structure to those that you can see the key differences and how you arrived at those, I think is the way to combine different analyses.
Thank you, Timothy. In the interest of time, if there are no more questions from the audience. Okay, one more question? Okay, one more.
Hey, Tim. Hi, Timmy. Good to see you guys, albeit remotely.
Hi.
This question is for the lawyers in the room. Let's say in principle, you and your client have taken a decision that the matter is clear enough and there's no need for an expert report, and that the lawyers can make statements of fact in the dispute proceedings. But the other side, in submitting their papers first, submits an expert report. Would you recommend that your client matches their strategy or their position by submitting a expert report? Or do you stick by your guns and say, well, we can make the relevant averments in our papers without the need for an expert report?
Thank you. Muyiwa, go first, and then Tomi-san could add compliment.
I think, like I explained before, is really the issue is who has the burden of proof and what are the consequences of that. And then the cost as well, and so many other factors that you have to consider. So if is the claimant, I'm assuming that I'm defendant, is the claimant that has the burden of proof on that point, I may then develop a strategy to say that I'm not going to call expert evidence until, or I mean, just saying if they then amend their papers later, I may consider it. But for now, I may decide that I'm not going to call an expert witness and then just build my case around them, discharging that burden of proof. Then you also need to, sometimes you might look at it and say, okay, there's a very high chance that they will amend their papers, or you don't know how the tribunal is going to assess the burden of proof anyway. So you might then want to go all the way and say, considering the cost, considering the time and everything, it's better for me to have the expert report now and then respond that way. So you just have to balance all of the factors.
Thank you. Tumisang, anything to add to that?
Yes, I'm going to give a typical lawyer's answer and say it depends. And it really depends on a number of things, including what's at stake. If there's quite a lot at stake, you may elect just to protect your client's position, file an expert report, which basically, on the face of it, you would have made a call and say it's not necessary, but you don't want a tribunal to say, well, I've got a view from one expert and I've got nothing on the other side. On the other hand, I fully agree with Muyiwa that sometimes where circumstances don't warrant that the client should spend the cost, you can adopt a different position. So it really depends.
Thank you for that. Just to wrap up now, in a very concise manner, I would like each of our panelists to give us 3 takeaways that they would like the audience to go away with on the subject matter at hand. I will begin with Colin.
Think carefully about your expert, engage early, and stay engaged with the expert through the whole process.
Thank you. Timothy?
Yeah, Colin's stolen 2 of mine, so I'll have to think of one on the fly. But yeah, definitely that ongoing dialogue. I think that's important with the expert, just to make sure that expectations around what is going to be provided by the expert in terms of deliverable, that expectations align. I think it's one thing. The second thing is try and strike the balance between experience as an industry expert and experience as an expert witness. And I think trying to juggle that is the key thing, and don't underestimate the latter, which is how someone will perform when put under pressure. And the third one is that the written product is very important. Not just the numbers and the calculations and the analysis, it's actually the way that's articulated is key. So an expert who can communicate is really important.
Thank you, Timothy. Tumisang?
Yes, I think firstly, expert evidence remains very relevant in the resolution of construction disputes. Number 2, get the right expert for your matter. Number 3, there are a lot of African experts. We just have to work together to bring them on board, to collaborate with them. But yeah, there are a lot of African experts. Thank you.
Thank you. Muyiwa?
I would say early engagement of experts, and then ensuring that the expert that you are engaging, apart from just having the expertise, must also have the capability to give evidence. And then I think those are just the 2 points that I would.
Thank you, everyone. Can we have a hand of claps for our panelists today? Thank you very much. And that's it from us today. Have a good afternoon.
Brilliant session. Thank you so much. Thank you very, very much. A round of applause once again.